Application to challenge the ANC's NEC decision to disband the Northwest PEC is currently happening. Let's go live.
The applicant simply saying that because of the impact of the unlawful decision, the matter is urgent. Paragraph 12.2, where they say that the decision is unlawful.
I'm not with you now.
At page 8, yes. And paragraph 12.1.
There's no 12 on page 8.
Page 8. Those will be the respondents' heads, first respondents' heads.
Yeah.
There is a paragraph 12, and it says applicant's motivation for agency. Does your lordship see that?
There's no paragraph 12, I repeat.
In our heads of arguments.
Yeah. Anyway, I'm on paragraph 16, that's the heading you're referring to.
So that will be page 16.
Yeah.
It will be paragraph 16
8.
of page 8.
Yeah, applicant's motivation for agency.
So applicant's motivation for agency.
That's what we're dealing with now.
Yeah, but the paragraph should be the same. Yeah, okay. So paragraph 12 of the heads that your lordship have, does it not have a heading which says applicant's motivation for agency?
I do have it, but there's no paragraph 12.
Oh, so the heading is there.
Yes.
And
But
then,
let's get on.
and yes, indeed. So what we're doing there, my lord, was to list 8 points which are raised by the applicants, and then we have taken them from paragraphs 26 to 49 of the applicant's founding affidavit, which I have already referred to your lordship to those paragraphs. And we say that none whatsoever in those paragraphs point to the agency of the matter, except that the court is told that the matter will be moot by February, something that we have pointed out that it will not be moot at all. So now, if lastly I can take your lordship to, I don't know if then the paragraph will accord then with what I have here, but I've already made that submission about the replying affidavit seeking to make out a case. So we deal with that, my lord, at page 12 of our heads, paragraph 20. And of course, that is a tight proposition of the law, my lord, that you cannot canvass in reply matters that you have not canvassed in the founding affidavit in an attempt to bolster the agency of the matter. So let me go back to the beginning, my lord, where I said that Rule 6.12b requires an explanation as to why the matter is urgent, meaning that you as the applicant, you must also see the matter as urgent, and the steps that you have taken must show that you have treated the matter as urgent before the court can even see it as urgent. So I would like to give your lordship the timelines to demonstrate that even the applicants never regarded the matter as urgent because they were litigating it leisurely. So the following timeframes, my lord, are important. I've mentioned that the decision to dissolve the PEC was taken on the 30th of August, communicated on the 31st of August. The applicant waited for 24 days and launched the application on the 26th of September 2018 with no explanation whatsoever in the founding affidavit to explain the delay. As Noche AJ has said that you've got to explain then that delay, every single day of delay you must explain it, which was not done. The application, your lordship will see on the face of the notice of motion, was set down for the 23rd. So it is brought on the 26th, almost a month later since the decision was taken, and set down a month later. So it is set down for the 23rd of October, 2018. But given this, my lord, let's look at what the applicants are giving to the respondents to file the papers. If your lordship can just go to page 3 of the notice of motion. So page 2 at the top, your lordship will see that the matter is set down a month later. So that is now 23 October. But then when we turn to page 3, paragraph 4, it says that the respondents must file by the 12th of October 2018. We can confirm, my lord, that the respondents did meet that deadline and filed on the 12th of October 2018. And then your lordship will see that the applicants themselves in the same paragraph, they said that they will reply by the 18th of October 2018 themselves. And it is common cause, as your lordship will even see from the court stamp of the replying affidavit, that they missed their own self-imposed deadline to file that replying affidavit. But quite extraordinary, my lord, is that
You mean the 24th and the 18th?
that is the
You mean they were filed on the 18th, but they only filed on the 24th?
that's right. Well, actually, then they gave it. They filed on the 22nd, or they served. They served on the 22nd. So probably the filing could have been a little later, but they served the signed affidavit then on the 22nd, which was a Monday, and they've set down the matter for the 23rd of October. But what is even quite extraordinary, my lord, is that the very applicant who has come to court to say that this matter is urgent because the conference is coming in February, on the 22nd of October, then they file a notice of removal from the roll. And the lordship will see it there in the court file. On the 22nd of October, they filed notice of removal of the matter from the roll. No explanation whatsoever.
Where do I find that in the papers?
Well, it should be in the court file, but we can hand up the one which was served on us because...
This is part of your index.
If I look at the index, it should be towards the end. Item 41 of the index, it will be page 456 to 457. Notice of removal from the roll.
Thank you, I do have it.
That's right. So now on the 22nd of October, they filed notice of removal from the roll. No explanation. This, it is filed or it is served in the afternoon on the 22nd. So this is the applicant who says that the matter is urgent and it must jump the queue. And your lordship has seen the affidavits about the skirmishes as to the re-enrollment of that matter, that in fact the judge was assigned the matter. Judge Madasela. So no, but I mean, I've read the papers, then I can proceed. But then I can assist you when you have the letter ahead. But the applicant was comfortable that we are comfortable with our removal. Then we'll set it down again. Then they set the matter down again for the following Tuesday, and that is now for the 30th of October, 2018. And the notice of set down is also then, will also be there in the court file. I see the notice of set down in the index is page 459, but I'm not sure whether it is the first set down or the second because it was removed twice. So Then the matter stand down on the 30th of October to the 2nd of November for the judge to hear the parties. Then the applicant then says, no, can't you agree that this matter then be removed and to be given special allocation? And we said it's fine, but the agency will still remain. The agency will still remain. So now, your Lordship has to evaluate the agency also in the context of the lackluster litigation of this matter by the very same applicant. But it points to something very fundamental as well, my Lord, this lackluster approach of the applicant, that the clinging to the February provincial conference as the basis for the agency of the matter is a red herring. There is no such a thing. We're told that 3 months is required for the preparation of the provincial conference. But the applicants were comfortable that the matter can be dealt with even in November or mid-November. So this is the applicant who say that everybody must sit and say that let's drop everything and let's look at these applicants because the house is going to collapse on in February because the provincial conference is being organized by an illegitimate structure. There is just no substance in such a submission, my Lord, to motivate for the agency. So, as we have said, my Lord, both in our answer affidavit and the heads of argument, that this is an application where the agency is simply self-created. Your Lordship should simply strike this matter from the roll of cost. Of course, your Lordship is going to be told that, well, if you strike it from the roll, it's going to come back anyway. Well, the applicants can't be advised what to do with their matter. It's up to them. If they want to come back later, they can do so. If they don't want to come back, they can do so. It is their choice. It is one of the constitutional rights that they have. But that can be the basis that in any event will come back. But when they come back, they'll have to come back in the normal course. And the matter will be dealt with at that stage. And the relief that they seek, they will still get it. Of course, we know that for the one of the reasons,
if you don't oppose it.
Yes, if you don't oppose it. And of course, if you don't oppose it, then they may get that relief. Indeed, your Lordship is correct. But all what I'm saying is that they will be afforded substantial redress in due course, and they have not motivated why they say that they will not be afforded substantial redress in due course. And that is fundamental to bring in urgent application. So if your Lordship can simply strike this matter from the roll with cost, and those costs should include the cost of due counsel. Those will be submissions on agency or not.
But before you go, could I get clarification on the two issues?
Yes, indeed, Mala.
One is the removal of the matter from the law. Are you arguing or saying to me that it was not by consent?
No.
In the parties to have the matter removed?
No, it was not by consent. The matter was removed from the roll without any warning to the respondents by simply serving the respondent with a notice of removal on the 22nd of October. So no warning whatsoever, no explanation whatsoever. So what I'm saying is that the applicant who said the matter is urgent, when it was already delayed, my Lord, in setting it down. Remember that I've given your Lordship two fundamental dates, important dates. The first one was the filing of the actual application a month later after the decision, the setting down of that application a month later. On the eve of the matter to be heard, then the same applicant removed the matter from the roll. Surely, an applicant who says that the matter is urgent will not do that. So that removal was not by consent. And the set down, my lord, of the matter for the 30th of October was also unilateral. It was a unilateral act by the applicant, despite that it was warned. So that is an important factor, my lord, to take into account. So those are submissions, my lord.
The second part, you may not be able to tell because you're not here on Tuesday. Why was the matter stood down on Tuesday last week until Friday?
From what I'm told by my junior, is that
I was not there. You were not there.
yes. So I'm saying hearsay, which is confirmed next to me.
It does not make it admissible. Anyway, it may be admissible.
But it is common cause that on the 30th. The matter was put down because the judge presiding was having a full load of other matters to consider and called the parties to come back on Friday. And the parties never came back on Friday because of that letter which was sent to the DJP to give it a special education.
But that letter was already sent on the Tuesday.
No, it's not that one. We're talking about the letter to the DJP was sent on a Wednesday.
Wednesday.
It was sent on a Wednesday. But the matter was stood down by the judge for Friday.
So it had nothing to do with the parties?
No, they did not do the parties.
Thank you.
As a court.
Thank you, my lord. The fundamental problem with the submissions made by Mr. Mukhari is the premise is factually inaccurate. Why? If your lordship goes to page 2 of the bundles of the record, now, that is the relief that we seek. Paragraph 2.1, we ask for the setting aside of the decision of the 31st of August, 2018. Now, we know, of course, that the decision was not taken on the 31st, but on the 30th. But paragraph 2.2, we also ask for the decision of the 20th of September, 2018, to appoint a PTT to be declared unlawful and set aside. Paragraph 2.3, we ask for an interdict against the activities of the PTT. Paragraph 2.4, we ask for the reinstatement of the disbanded PEC. Mr. Mukhari has repeatedly told your lordship that it took us 24 days to come to court after the decision was taken. What he failed to do was to bring your lordship squarely to the terms of the notice of motion to see that the decision that we are challenging is the disbandment plus the appointment of the PTT plus we seek an interdict. We then look at when did we come to court. We came to court on the 26th of September, 5 days after the decision in 2.2 was taken. That is a weighty factor. Plus 2.3, we seek an interdict going forward. My clients do not want the PTT to perform any activities because they believe its appointment is illegal. If one looks at the constitution of the ANC, to look at the scope of the authority of this PTT, at page 98 and 99. If one looks at page 98, Rule 19, which sets out the authority of the PEC. In 19.1, the PEC is the highest organ of the ANC between provincial conferences and has the authority to lead the organization of the province. 19.3 up to 19.7 explain how it is composed. In 19.9, the powers and duties are set out. 19.9.2, it must carry out the policies and programs of the ANC in the province and do all things necessary for the further interests, aims, and objectives of the organization. 19.9.5, manage and control the funds and assets of the ANC in the province. 19.9.7, issue and send directives and instructions to and receive reports from regions, branches, and other substructures of the province. You turn the page to page 99. 19.9.12, ensure that the provincial, regional, branch, and other structures of the ANC in the province function democratically and effectively. In this regard, the PEC is empowered to, and the one that's highlighted, 19.9.12.2, to suspend, dissolve, relaunch branch executive committees, regional executive committees where necessary, subject to directives from the provincial conference. Now, this body, called the PEC, exercises substantial powers that have an impact not only to members of the ANC, but to the government as well. We contend that the PTT, which is unelected, appointed by the NEC, has now assumed all of the functions that are outlined in the Constitution. The assumption of those functions is illegal. Now, if your Lordship has regard to a judgment that we cite in our heads of argument, I think I should hand up. I updated the heads that were given by reference to additional authorities. Thank you. If your Lordship has regard to page 7, paragraph 22 of our heads of argument, we cite the authority of 20th Century Fox Film Corporation and another, which makes the principle the determination of urgency, a court must accept the arguments in the founding affidavit to be correct. So, if your Lordship's premise is to accept that what the applicants say is correct, what do the applicants say is the problem? Firstly, the PEC that was dissolved on the 30th of August 2018 was elected on the 15th of February 2015. And your Lordship will see that from the report that was given at the National Conference at page 183, paragraph 2.1. The process by which that election took place is described at page 96 and 97. of the Constitution. And that was done by branches. The branches has been described in the Constitution of the ANC as being the basic unit of the organization. And your Lordship will see that description of a branch as the basic unit of the organization at page 102, paragraph 23.2.4.
I assume that you are still arguing the question of age.
Yes, I am. Paragraph 23.1. Every member of the ANC shall belong to a branch, which is the basic structure of the organization. Paragraph 23.2.4. The branch shall be the basic unit of activity for members. So what happens is this. In 2015 February, branches attend to a provincial conference. They elect a PEC. It is entitled to remain in office for a period of 4 years. That period of 4 years lapses in February 2019. The Lordship will recall what Mr. Mukare said, that an elected PEC has no right to remain in office. Now, the statement is in conflict with the provisions of the Constitution. If we look at page 98, (19.1), the PEC is the highest organ of the ANC in a province between provincial conferences and has the authority to lead the organization in the province, subject to the provisions of this Constitution. So between the conferences, the authority is vested to the PEC as the highest organ. And then 19.3, 19.4, we've already referred to those. It remains in office, duly elected under the Constitution, until next February, when the new conference will be convened and the branches will elect. Now, if we start there as our premise, that we have a body that is constitutionally entitled to be in office for 4 years until the next provincial conference, what happens here?
Surely that is subject to the NEC not intervening.
Yes, precisely.
Yeah.
The premise, though, is you are entitled to be in office for 4 years. What are the powers then of the NEC? Those powers are described in page 92. Rule 12.2.4. Without prejudice to the generality of its powers, the NEC shall ensure that the provincial, regional, and branch structures of the ANC and NEC function democratically and effectively. So, the general rule in the clause is that the duty of the NEC is to ensure the democratic functioning of the structures. And then there is a discretionary power. The NEC may suspend or dissolve a PEC when necessary. The two obviously must be read together. The first part of the sentence is ensure that they function democratically. The exception to it is dissolution or suspension where necessary. Necessity is obviously not defined, but in the context of the sentence, necessity must refer to the failure to function democratically, because that's the default position. Now, we started off by explaining that we have a PEC constitutionally entitled to be in office for 4 years, and then we have a limited power of the NEC to intervene. But that limited power is qualified by the obligation to ensure primarily that the PEC functions democratically, and then, as an exception, to dissolve where necessary. My clients bring two claims before your Lordship. My clients are members, ordinary branch members. Their rights, if if your Lordship goes back to my heads of argument, page 5. Under the heading of urgency. These are the extracts from the finding in Ramakatsa of the Constitutional Court. If you look at the first finding, paragraph 16, I do not think that the Constitution could have contemplated political parties could act unlawfully. On a broad purposive construction, I would hold that the right to participate in the activities of a political party confers on every political party the duty to act lawfully and in accordance with its own constitution. This means that our constitution gives every member of every political party the right to exact compliance with the constitution of a political party by the leadership of that party. So, whenever the NEC wishes to interfere with the right of the members who have elected a PEC and instructed them to remain in office for 4 years, that political party is constitutionally obliged to act in terms of its constitution. And members have the corresponding right to exact compliance with the constitution. Paragraph 17 that we cite is also a crucial paragraph, which is incidentally, actually, paragraph 17 also from Ramakatsa. The appellants make serious allegations of irregularity and impropriety against the political party. The allegations go to the core of the propriety of the election in the Free State Province. If it turns out that the appellants are right in their allegations, the political party in the whole of the province will be governed over the next 4 years by an irregularly appointed provincial leadership. And the size of the political party is not necessarily decisive. Suffice it to say that the political party we are concerned with here cannot be said to be insignificant. The importance of the requirement that members of political parties should not be governed by an irregularly elected leadership cannot be overemphasized. The Lordship will remember those two passages were made by the Constitutional Court in the context where they were expressing their displeasure at the approach taken by the Judge Akuo in preventing the ventilation of the merits of the case on technical grounds. And the court said it's crucial that members of a political party are governed by a regularly, correctly elected political party. And then warned that in circumstances where this does not happen, this has a spillover to the government. The party we are dealing with here, which is the ANC, is the governing party in Northwest. It is not an insignificant party. If it turns out that the decision made by the NEC on the 30th of August and on the 20th of September, if it turns out that both of those decisions were illegal, the consequences are not only felt by my clients, the consequences spill over to the governors of the province in general. This is why it is crucial not to resort to an overly technical approach in a case of this magnitude. We say here the same allegations of impropriety are made against the ANC. And if your Lordship has regard to the 20th Century Fox decision, if you have to accept the allegations we make against the ANC, the allegations of irregularity and impropriety, accepting those to be correct, then it becomes abundantly clear that we have a PTT that is illegally occupying office, and that the decisions that they will be making, whether they are dissolving branches, dissolving regions, or for that matter, interfering with the running of the government, those decisions are themselves illegal decisions. As a matter of law, it is improper to allow an irregularly appointed PTT to remain in office.
Can I just make sure we are on the same wavelength?
Yes.
They may be illegal, but that still has to be proved.
It depends on which part is illegal.
It still has to be proved.
Yes. It depends, my lord, on, as your lordship finished.
No, I have not.
Yes,
Step
sorry.
mine.
Yes, sorry.
Step mine.
Yes,
not
yeah.
trend.
Yes, that was the intention.
It's worse than intentionally. But yeah, I was going to proceed by saying that has to be proved still whether they are unlawful or not.
Yes.
But here we're concerned about the venue of the news.
Yes.
The agent court, is it? No more.
Yes. Now, for purposes of urgency, yes, I think we are on the same wavelength, my lord. For purposes of urgency, you must accept what the applicants say is unlawful to be true. That is the law in 20th century. It's been followed by this division. So you've got to take what the applicant says are the irregularities and accept those to be true in order to decide whether the case is urgent or not. That does not mean that you accept what we say for the merits. But for the decision on urgency, you accept what we say as an irregularity to be true. So in other words, Your Lordship approaches this case on the basis that the PTT is illegally occupying office. They are squatting. They should leave. That's the premise through which Your Lordship approaches the question of urgency.
So it will remain urgent for a long time.
It will remain urgent for a long time, exactly. But the starting premise is accept that their occupation of the office is unconstitutional, violates members, and they are likely, because they don't actually hide this, they will continue making decisions that will impact not only on members, but on government as a whole. So, this is why I started by illustrating how the constitution of the ANC functions in order to come to the question of urgency, to see that what we are dealing with here is a group of people that were appointed, not elected, to replace people that were elected in circumstances that are plainly illegal. So if then that is the premise from which we begin in assessing the question of urgency, we might then entertain the objections that are raised by Mr. Mukari. Yes. The objections that are raised by Mr. Mukari. The first objection is you've taken too long to come to court. But that is not a difficult objection because a simple assessment of the notice of motion shows, Your Lordship, that we haven't taken too long to come to court. We are challenging two decisions. We're challenging the dissolution. We are also challenging the appointment of the PTT. We say that PTT is illegal. And this is not a disjuncture because although the decision to dissolve was taken on the 30th of August, it was only operationalized. Its impact only came when the PTT was appointed because the PEC, whose dissolution was announced, continued in office until the 20th of September 2018, when Mr. Makashule announced that there would now be a new PTT. You will see this from the papers at page 77. So page 77 is the first decision, which is the decision of the 30th of August, communicated on the 31st of August. And Your Lordship sees at page 77 first that a resolution is announced, and then the second part is that there is an agreement to set up an inclusive PTT, and then in paragraph 78, the sort of terms of reference of the PTT are announced, and then page 79, the first paragraph, then it says the NWC will also elaborate on the terms of reference to guide the work of the PTT, which will be supported by the NEC deployees in the province. That decision was a pure announcement, not operationalized. If you go to page 80, there they put into operation the decision. What is the date? 20th of September 2018. They start off by saying the special session of the NEC on 30 August 2018 resolved to intervene in the Northwest Province to strengthen the organization and enhance its capacity to meet its mandate to the people of the province. The NEC agreed to set up an inclusive PTT that will be seized with the task of uniting the organization and positioning it an effective leader of society. Then they announce who those people will be and who will be reinforcing them. So, insofar as the first objection is concerned, that you've taken too long to come to court, it is empty of fact because it ignores the fact that although the announcement, the first announcement is made on the 30th, it is operationalized on the 20th of September because the PEC remained in office between the 30th or the 31st until they decided who the replacements were going to be. And it's clear why that is so, is because they had not even agreed on the terms of reference of the PTT. Because the decision was, we will ask the National Working Committee to decide for us what the terms of reference are going to be. That seems to have taken time on the ANC side, and it was only finalized on the 20th of September 2018, when both the terms of reference were decided and the members of the PTT were announced.
But by then the PEC was dead.
Yes, it was
By this date.
by the 20th.
Yeah.
No, that is what killed it.
Yeah.
It's the replacement of the PEC by the PTT. Absolutely. So before the 20th of September, the only thing that had been announced is the dissolution, but it had not been operationalized. The operational date is the 20th of September. So if your Lordship works from that basis, that the operational date is the 20th of September, you can then ask, when did you bring your application? That is answered at page 4 and 5 of the papers, because that's where the service pages are. It's issued on the 26th, served on the 26th. So in reality, you are dealing with a non-complaint, because you're dealing with people who are complaining about 6 days. In any event, so far as the disbandment itself is concerned, your Lordship should take into account what is contained at page 306, which the ANC knows about. And this is the letter of demand written by Mr. Mabuza. And he specifically explains what the complaints are, and he explains why his clients, the applicants, allege that the decision falls to be set aside. And in paragraph 9, he makes a specific demand. In the light of the above, we are instructed to demand, as we hereby do, that the decision to disband and appoint a provincial convener be revoked. Further, we hold instructions to demand that the PC is reinstated, failing which our clients will approach the High Court on an urgent basis for the appropriate relief. So this was in response to the pure announcement of the dissolution, which we contend is given teeth on the 20th of September. So, to recap on this point about unreasonable delay, we've got the 30th decision communicated on the 31st, which is an open decision because at that point the PEC remains in office. Even on the terms outlined by the NEC itself, it says the NWC still has to decide the PTT. The NWC still has to decide the terms of reference. We've got the 5th of September where Mr. Mabuza writes to the ANC and he says to them, we have a problem with your decision. We are asking you to set this aside. We are asking you to reinstate. That letter, my lord, is totally ignored. There's not even a letter of acknowledgement that we have received it. They completely ignore it. And then we have the 20th of September, where they give effect to the decision. And then you have the challenge being instituted on the 26th of September. So, properly speaking, there has been no unreasonable delay at all. Of course, when your Lordship explores the question of unreasonable delay, your Lordship will be guided by lunar mobiles. And the principle in lunar mobiles is that practitioners must decide what timelines are appropriate to afford the respondents to respond. What we know here is that the respondents were given more than adequate time. They were given more than the 10 days that is required. They've put up their answering affidavit. They have nothing more to say. They have pleaded their case in full. They have even filed heads of argument in full. So insofar as this question about delay, it must be weighed with whether or not it has produced any prejudice to the respondents. In fact, in this case, it has worked to their advantage because they have had more than enough time to put up an answer, to put up whatever evidence they wanted to put to the court. So we are dealing with a court that is fully seized with the merits of the case. And we are dealing with a case that is fully pleaded. And we are dealing not with an ANC that says, look, you've jumped the gun, it's too soon, you've prejudiced us. Not at all. And agency is then pursued purely for self-serving reasons of simply delaying the achievement of relief by the applicants. And their strategy is actually revealed in the exchange when your Lordship is asking about what will actually happen in February next year. They say, well, they will get the relief they want. And your Lordship asks jokingly, if you don't oppose. What's clear is that agency has been contrived as a defense purely in order to frustrate the applicants obtaining relief in circumstances where the decisions are purely indefensible. The fourth aspect to address on this question of agency is 612 itself. Your Lordship knows the two factors that are in Rule 612. The first is an explanation of the objective agency of the case. We've given the explanation about the objective agency of the case, and your Lordship can now appreciate that contrary to what Mr. Mukhari tried to suggest, there has been no unreasonable delay in the institution of the application. If anything, the applicants have acted responsibly in allowing the ANC enough opportunity to put in an answering affidavit, and where matters stand right now, the ANC is not complaining of any prejudice. Then there's a second leg to 612, which is whether or not you will be afforded substantial redress in due course. On the facts that we have, my Lord, it is clear that we will not be afforded substantial redress in due course at all. Why? Our term of office, current PEC, lapses in February 2019. Under the Constitution, we are entitled to remain in office until February 2019. The members who elected us are entitled to have their elected representatives remain in office until February 2019. The dissolution interrupts the term of office, and it illegally does so because it's a dissolution that goes against the provisions of the Constitution. Mr. Mukhari says there is some other world where after the end of your term of office, you can come to court and get an order that reinstates you. That is just a dream. Once the term of office has ended, the plan is simple. They are now going to convene a new provincial conference. And that provincial conference, it's common cause. We've pleaded that. The provincial conference will be organized by the PTT. Once, which we contend is unlawful, once that PTT has organized a new provincial conference, that is it. That is the end of the term of the PEC. Any new PEC that is elected itself is entitled to a period of 4 years. So if we are not heard on urgency, the consequences are catastrophic because it means that those members who sat in Bojanala in February 2015 purported to exercise their rights of membership could have those rights taken away unilaterally with no process, with no valid reasons, by 80 people. This is not how the ANC functions. In Rule 3, it makes it clear that it is premised on democratic accountability. In Rule 4, it makes it clear that there's a reciprocal relationship between the elected and the electors. In Rule 5, it makes it clear that each member of the ANC is entitled to participate in the democratic affairs of their organization. The most important right that these members that I'm representing are asserting is the right to elect a leadership. Once they have exercised that right, it should not be taken away by 80 people who themselves are not the controllers of the organization. The organization is controlled by branches, which are the basic unit of the organization. So it is a folly to suggest that sometime in the future we will be able to come back to court and obtain the relief that we seek to obtain here. The only time we can obtain this relief is today. And, Your Lordship, Mr. Mukari refers to Section 172 of the Constitution. But Your Lordship knows that the premise of Section 172 of the Constitution is effectiveness. Can you give us effective relief after February 2019? The fact is that you can't, no one can give us effective relief after February 2019. So the consequences of a striking on the basis of urgency is that we must arrange again with the DJP for another hearing, again on an urgent basis, in order for us to make sure that the term of office does not lapse in our hands.
For the third time.
For the third time.
Yes.
Which is absolutely absurd.
Because of the applicants.
In what way?
The manner in which you present your case to the agent court for the third time.
Well, I'll come back to that issue about the third time, because the so-called agreements, because there's actually a lot of material there that's overlooked. So, to finalize this point, what we are dealing with here is a total abuse of the court process. We will ultimately be required to ask the DJP to give us another judge to hear the case. It's a waste of judicial time, waste of everybody else's time, and most importantly, it is a flagrant violation of my client's rights to access to court. And it allows the ANC literally to get away with murder in circumstances where Your Lordship can see the illegalities that we plead. The fifth point, which is, I think Your Lordship has already started hinting about it. No, I wanted to address it, my Lord, because it's not Your Lordship's point, it's Mr. Mukari's point.
Yes.
What he says is that it does not matter if your case is urgent, it does not matter if you can't obtain relief in due course, you've mismanaged the litigation, and therefore you should be non-suited. But the allegations of mismanaging the allegations are unfounded. The first basis on which he says the litigation was mismanaged is that we gave them a lot of time to respond. But that is just absurd. We gave them a lot of time, that is to their benefit, so that they don't complain that they did not have enough time to respond. And Luna Mobiles specifically says advocates must make sure that they give the other side enough time to respond, so that no one comes to court and complains about prejudice. So the fact that we gave them enough time to respond was a good thing for the proper management of the case. And then he says we set the case a month later, but precisely so that the issues in this case of this significance can be properly ventilated. That cannot be criticism against the applicants. And then he says, well, when the case was set down, you had scheduled to bring your replying affidavit on the 18th, you brought it on the 22nd. But that is precisely why Mr. Mabuza, my attorney, removed the matter from the roll, because it was not ready to proceed on the 23rd, in accordance with the practice directive of this court, because the papers had not been properly indexed and properly paginated on the Thursday before the 22nd. Before the 23rd. Then the fourth part that they rely upon is the removal on the 30th. It's not clear why they're complaining about that removal, because I was in court.
Without consulting them.
No, my Lord, there are no facts to that effect. I just asked my attorney, as Mr. Mukari was speaking, whether or not he communicated with them about the removal on the 23rd. He says they did. In fact, the only complaint that remained was a complaint about costs. And I didn't come to court, my pupil came. Mr. Mukari didn't come to court on the basis that he was released by his attorney from coming to court. So Mr. Mukare wants to give the evidence, well, then that takes us into a dangerous terrain. Because I took 5-minute instructions now as you were speaking, and I have a completely different narration of what transpired on the 23rd. But in any event, this thing about what happened on the 23rd cannot be decisive in a case of this significance. So
there will be a dispute of fact.
Precisely. And ultimately, it is not decisive on whether or not your Lordship, in the overall exercise of discretion, should hear the case as urgent or not. But then we go to the last leg of Mr. Mukare's submission, which is, look at what they did on the 30th. I was in court on the 30th. Mr. Mpofu was in court on the 30th. We had an acting judge, Frowley. She called us to chambers and said, I have a long roll, 40 cases, 16 cases on the day. What do you gentlemen want to do? We said we are happy to be allocated any time in the week that is convenient, except a Thursday. I think Mr. Mpofu had a difficulty for the Thursday. Oh yes, and Mr. Mukare was not in court at the time. I think he had a disciplinary hearing. She then agreed. No, where he was acting for one of the parties. He was counsel in the DC. She then told us that we should come back on the Friday, which was agreed. No dispute about that, because you don't want to burden the court unnecessarily. What happens is that there is a proper reflection after that we are overburdening the court. It has so many other cases. Our case will be argued for the whole day, most likely, 4 hours. But we had forced ourselves to give 2 hours in order to be in. That reflection resulted in a discussion among counsel and an agreement that we should rather, because the case is important constitutionally, it's important nationally, it's also about 500 pages, that we should simply approach the DJP to give us a special allocation. The only reservation in that instance was the reservation put to me by Mr. Mukare, who said, we still want to raise the issue of urgency, which I agreed with. So these complaints appear to us to be utterly contrived. The complaints around when the case was removed and when it was not removed, because at the end of the day, everybody agreed that this is a case of importance, it is a case that is complex, and it is a case that requires a special hearing. And once you factor in that in everything that has been said by the ANC, there has not once been a reference to prejudice. Not once has been a reference to prejudice. Then why are we not hearing the case? There is just no reason why we are not hearing the case. It's simply raised for convenience, kick us out, and then hopefully kick for touch as well. And so we would submit that a court should not be used in this fashion. A court is primarily interested in doing justice for the parties. And if there is any irregularity, as we submit here, it is plain that irregularity needs to be stamped out now. So, my Lord, we would submit that what's also clear from what Mr. Mukare was saying is that in any event, the questions of urgency are interwoven with the questions of the merits of the case. He tried to argue the case on the merits. We don't want to take that line. We still have the rest of the day to do that, if Your Lordship entertains the hearing. Those are the submissions.
Thank you.
As the court pleases, my Lord, just so that I
have not been covered by the argument.
I have, my Lord. That's exactly what I was about to say. I will restrict myself to any additional material so that we don't waste more time than we already have. And for housekeeping, my Lord, if I may, I've already handed up to Your Lordship the judgment of Ramakatsa. If I may also hand up to Your Lordship 2 other judgments, which I will refer to briefly. The one is Prinsloo versus RCP Media Limited, and the other one is Patricia DeLille versus Democratic Alliance. I'll just refer to the relevant passages so that just to situate what I'm about to say, my lord. In the DeLille case, I think it's paragraph 54. The Lordship will see that there's the reliance on an issue that Mr. Mugaitobi referred to. So it's also an indirect reliance on Ramakatsa in the middle of that paragraph. The right that we are talking about, my lord, we say it was further contended that the dictum in Ramakatsa that, quote, our constitution gives every member of every political party the right to exact compliance with the constitution of a political party by the leadership of that party. And then, if your lordship could just quickly go to paragraph 62, where again, with approval, the court quoted from a case that we relied on of Crowcamp. And that quotation says, it is common cause that the civic, as a political party, in that case, is governed by its constitution, which represents the collective voice of its members. This constitution spells out clearly when and how members of the civics NEC will be appointed and removed from office. It follows, therefore, that the NEC is constrained to exercise only those powers entrusted to them by the Constitution, and strictly, very important, strictly in terms of the Constitution. This is in line with the principle of legality. Any conduct that falls outside the purview of the Constitution is therefore ultra vires and invalid. The operative words in both quotations is exact compliance, and here it is strict compliance, and only those powers, otherwise you fall foul of legality. What has that got to do with this case? It simply says, my lord, these extracts must be read. This was a full bench decision, by the way, of the Western Cape, which confirmed, or rather relied on Ramakatsa. These extracts, my lord, with the greatest respect, must be read in conjunction with the dictum in Century Fox that my learned friend Mr. Mugaitobi referred to. And this is one of the most forgotten principles when we talk about agency. And that's why I don't understand a respondent who actually insists that agency must be debated up front, because it's just suicidal. Because at the stage of agency, the court is enjoined to assume, right, that all the averments that are made by the applicant are true. If we were arguing this matter together with the merits, that assumption the court would not be entitled to make. But because of the method that they have chosen, this court has no option but to assume that what we say in the affidavit is true. So what is it then that we say? The Lordship has already been referred to paragraph 12.
All right, we're going to come out of that application to challenge the ANC National Executive Committee's decision to disband the Provincial Executive Committee in the Northwest, being heard in the Johannesburg High Court. So today,